A quorum being present, the subcommittee will come to order. Good morning. Today, the subcommittee will examine a number of legislative proposals intended to provide greater transparency and accountability to the Equal Employment Opportunity Commission. I'd like to thank our witnesses for joining us. We have a distinguished panel to help us look at a number of complex and important issues. All workers deserve strong protections against employment discrimination. Toward that end, there continues to be support for federal laws such as the American with Disabilities Act, the Civil Rights Act, and the Age Discrimination in Employment Act, and others. There is no doubt that every member of the committee expects the fair and vigorous enforcement of these laws in our nation's workplaces, and that is precisely why we are here today. The Equal Employment Opportunity Commission plays a vital role ensuring America's workers are free to pursue employment without fear of discrimination based on their race, their gender, their disability, or religion. We need this agency to do its job effectively so that every American has a shot to succeed based on merit and hard work. Unfortunately, the enforcement and regulatory approach adopted by EEOC in recent years raises serious doubts about whether our nation's best interests are being served. For example, the Commission has implemented controversial guidance on the use of criminal background checks that will make it more difficult for employers to protect their employees and customers. At a hearing held last Congress, the subcommittee received testimony from Ms. Lucia Bone, whose sister, Sue Weaver, was murdered by a man who months earlier had cleaned the air ducts in her home. A simple criminal background check might have saved this woman's innocent life. State and local policies requiring criminal background checks are intended to protect Americans who come in contact with workers in vulnerable situations, such as home and in the classroom. As a result of EEOC's misguided policy, more Americans will be put in harm's way, including women and children. The EEOC should scrap this misguided policy completely. But if it won't, then Congress should take steps to rein it in and help provide families greater peace of mind the next time they invite a stranger into their home or a child's classroom. Furthermore, EEOC has challenged employee wellness programs. Employers develop these innovative programs in order to improve the health of employees and their families, increase productivity, and reduce health costs. Yet litigation pursued by the Commission is actually discouraging employers from implementing these programs, even though Congress on a bipartisan basis has expressed its clear support for employee wellness programs. Lastly, EEOC is spending more time and resources pursuing systemic or class action investigations, often without any allegation of wrongdoing. The Commission has also been sanctioned in recent years for pursuing claims that are frivolous and without merit. This is how one federal circuit court described the EEOC enforcement action, and I quote, "EEOC brought this case on the basis of a homemade methodology crafted by witness with no particular expertise to craft it, administered by persons with no particular expertise to administer it, tested by no one, and accepted only by the witness himself. Meanwhile, a backlog of discrimination claims filed by individual workers continues to plague the Commission. This is no way to run an agency with a mission as important as the EEOC's, and we must demand better. To help workers succeed in the workplace without fear of discrimination, Congress has a responsibility to hold the Commission accountable for its regulatory and enforcement policies. We will examine today a number of legislative proposals to help us do just that. Together, these proposals will instill greater transparency and accountability in EEOC and improve its enforcement activities, and help more workers and employers enjoy the benefits of employee wellness programs. I look forward to discussing in greater detail with our witnesses the positive reforms in these bills and hope they will receive strong bipartisan support. With that, I will now recognize the ranking member of the subcommittee, Representative Wilson, for her opening remarks.
Thank you, Mr. Chairman. Today, we will examine 4 bills that would impact the Equal Employment Opportunity Commission, EEOC, in ways that I fear will compromise the enforcement of civil rights laws. Since 2014, we will have had 3 hearings regarding the EEOC. Yet, we have not once invited the commissioners themselves to testify about the bills that could severely impact their enforcement of employment civil rights laws. The name of this subcommittee is Workforce Protections, and by our name alone, it is clear that we should be doing our best to protect workers. These 4 bills appear to be a grab bag for unscrupulous employers seeking to strip the EEOC of the tools they need to combat employment discrimination on the basis of race, color, religion, national origin, sex, pregnancy, age, disability, and genetic information. 50 years ago, after the creation of the enactment of the Civil Rights Act of 1965 and the creation of the EEOC, the job of the EEOC is far from complete. Despite many advances, Mr. Chairman, these 4 bills today ignore the fact that race, gender, disability, and age discrimination persist, and we should not be hindering the agencies charged with combating unlawful discrimination in fiscal year 2014. Just for example, in fiscal year 2014, of the 88,778 discrimination charges filed with EEOC, 35% were based on race, 29% were based on sex, 29% were based on disability status, and 23.2% were based on age discrimination. Mr. Chairman, I'm at a loss to understand why we would want to tie the hands of the EEOC, an agency that has a backlog of 70-plus charges. Here's how we would tie their hands. Number 1, stripping the General Counsel's authority to make a determination about what charges the EEOC should pursue to protect American workers, given there is a policy in place to ensure novel legal questions and controversial matters must already be submitted to the Commission for approval. Number 2, limiting the EEOC's disparate impact examination of criminal background checks. Even Clarence Thomas, Commission Chair in 1987, adopted the agency's guidance, which says that the criminal background checks, like other hiring requirements that could exclude certain people, should only relate to the job. Number 3, granting liability exemption to employers who violate employee privacy and civil rights under the American and Disabilities Act, ADA, and the Genetic Information Non-Discrimination Act, GINA. And number 4, finally undermining the successful conciliation process by imposing legal hurdles to resolving cases and opening the process to extensive litigation based on the adequacy of the conciliation process rather than resolving the substance of whether or not there are impermissible discrimination. EEOC's job should be about getting results, not providing full employment for law firms looking for new ways to frustrate resolution of a disputed discrimination case. Mr. Chairman, I would ask that you call another hearing where we can review these 4 bills with all 5 of the EEOC commissioners. We need to assess the implications of these bills and determine whether they are unintended effects, such as piling on delays in resolving cases. We need to hear from the commissioners to determine whether these bills will set up roadblocks for fair and timely resolution of claims by those who face race, sex, age, or disability-based discrimination. We want to determine if these bills as drafted will spawn unnecessary litigation and create more confusion. I thank the witnesses for being here today, and I look forward to hearing your testimony. Thank you so much for coming. I yield back to the chairman.
I thank the gentlelady. Pursuant to Committee Rule 7C, all subcommittee members will be permitted to submit written statements to be included in the permanent hearing record, and without objection, the hearing record will remain open for 14 days to allow statements, questions for the record, and other extraneous material referenced during the hearings to be submitted in the official hearing record. It's now my pleasure to introduce our distinguished panel of witnesses. Mr. Paul Kehoe is a senior counsel with Cyphers Shaw Law Firm here in Washington, D.C. Mr. Kehoe is a member of the Cyphers Labor and Employment Practice Group and a former attorney advisor to the Honorable Victoria A. Lipnick, EEOC Commissioner. His practice focuses on all aspects of employment discrimination law, including the development of strategies to prevent and resolve employment discrimination litigation under federal and state anti-discrimination statutes. Welcome. Tamar Simon is a managing director with Buck Consultants Knowledge Resource Center here in Washington, D.C. Ms. Simon is responsible for Buck's national multi-practice legal analysis and publications, government relations, research, surveys, training, and knowledge management. She serves as a national resource on compliance issues affecting employers' health and welfare benefits. Welcome. Tanya Clay House is the Public Policy Director at the Lawyers Committee for Civil Rights under Law here in Washington, D.C. Mrs. House works closely with all Lawyers Committee projects focusing on core issues such as education, voting rights, employment discrimination, fair housing, affirmative action, criminal justice, immigration, and other racial diversity issues. Welcome. And finally, Gail Harriet is a professor of law at the University of San Diego School of Law in San Diego, California. Professor Harriet is a member of the U.S. Commission on Civil Rights. She teaches and writes in the areas of civil rights, employment discrimination, product liability remedies, and torts. Welcome as well. I will now ask our witnesses to stand and raise your right hand, as is the custom in this committee. Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Let the record reflect, you may be seated, the witnesses answered in the affirmative. Before I recognize each of you to provide your testimony, let me briefly explain the lighting system. Just as in the traffic lights, red it means stop, but you get to that by going green for your first 4 minutes. Yellow will be indicative of a final minute before the red light comes on. We'll ask you to finish as quickly your thought after the red light appears. I'll ask the same of the panel, though I may not be quite as stiff as our full committee chairman, Mr. Klein, yet I will do my best to follow suit. I'll now recognize Mr. Kehoe for your 5 minutes of questioning.
Chairman Wahlberg, Chairman Klein, Ranking Member Wilson, and members of the subcommittee. Thank you for inviting me to testify today on behalf of the U.S. Chamber of Commerce. The Chamber of Commerce is a long-standing supporter of reasonable and necessary steps designed to achieve equal employment opportunity. However, the Chamber has serious concerns as to how these laws are currently being administered and enforced by the EEOC. No matter how well-intentioned, any law enforcement agency's judgment, including the EEOC, can become clouded by hubris and susceptible to overreach. Too often, courts have taken exception to the EEOC's shoot first, aim later tactics. For example, just last Friday, a judge awarded attorney's fees to 2 companies forced to defend themselves against what the court called frivolous litigation. Just a month ago, a Fourth Circuit judge issued a scathing opinion against the EEOC for not being vigilant enough to avoid abusing the power that Congress bestowed upon it. These and other litigation embarrassments can be blamed in part on the Commissioner's lack of control over the EEOC litigation program. Only commissioners have the statutory authority to initiate litigation. In 1996, the commissioners delegated away much of this authority to the General Counsel, who then redelegated away to regional attorneys. The Commission partially rescinded this delegation in 2012, but problems persist. Far too often, commissioners learn about litigation by an EEOC press release or social media. The General Counsel or unappointed, unconfirmed regional attorneys are making policy through litigation. However, any EEOC General Counsel is the agency's litigator, not its policymaker. For 40 years, courts have reviewed the EEOC's statutory conciliation efforts. In 2013, a Seventh Circuit court rejected this statutory safeguard, finding conciliation not subject to judicial review. This issue is currently before the Supreme Court in EEOC versus Mock Mining, where the EEOC argued that as a law enforcement agency, its actions related to whether it complied with statutory mandates are not reviewable. This position is simply breathtaking in scope and encourages the EEOC to purposefully eschew conciliation in search of the next lawsuit, the opposite of congressional intent. All of the issues that have plagued the EEOC recently were on full display in EEOC versus Honeywell, a case filed by the EEOC seeking a preliminary injunction to prohibit Honeywell from offering financial incentives pursuant to a wellness program. The EEOC received charges on October 16, 2014, determined that day that a violation of the ADA and GINA occurred, demanded that Honeywell stop using financial incentives, and filed litigation 11 days later. However, the Affordable Care Act, HIPAA, and joint regulations issued by 3 cabinet-level agencies permit, indeed encourage, financial incentives in wellness programs. The EEOC's theory was that the incentives made participation non-voluntary under the ADA and GINA, even if the incentives complied with the Affordable Care Act and its implementing regulations. One district office believed so and filed suit without commissioner approval, seeking to establish a policy position never adopted by the commissioners. This rogue agency strategy will likely have a chilling effect on the development and implementation of wellness programs. Ultimately, the EEOC's choice to focus on systemic litigation with questionable theories has caused it to ignore instances of more traditional types of discrimination, leaving alleged victims and their employers in limbo, literally, for years. A decade ago, the Commission would file almost 375 lawsuits annually. Despite an increased budget in 2010, the EEOC now files only 130. One can rightfully ask what the EEOC is doing with its sizable budget, as it is clear that all too often they are not investigating promptly, not conciliating in good faith, and not litigating very well. Justice Brandeis once said that sunlight is the best disinfectant. The 4 bills under consideration today would provide that sunlight, and our common sense, narrow solutions to these issues. H.R. 549 will ensure that policymaking is rightfully returned to the commissioners in all multi-victim litigation that the EEOC pursues. H.R. 550 will clarify the EEOC's duty to conciliate and ensure that such efforts are reviewable in court. H.R. 1189 will ease the uncertainty created by the EEOC's litigation against Honeywell. Finally, H.R. 548 provides clarity for employers faced with state or local mandates prohibiting the hiring of certain convicted felons for certain positions. That is all that it does. Overall, these bills should enhance the EEOC's functionality and accountability, and the Chamber supports them.
Thank you. Now recognize Ms. Simon for 5 minutes of testimony.
Good morning, Chairman Wahlberg, Chairman Klein, Ranking Member Wilson, and members of the subcommittee. My name is Tammy Simon, and I'm Managing Director of the Knowledge Resource Center and the Career Practice at Buck Consultants, a Xerox company. It is my honor to testify today on behalf of the American Benefits Council, of which Buck Consultants is a member. Collectively, the Council's members either sponsor directly or provide services to employee benefit plans that cover over 1 million Americans. Many of the Council's members are at the forefront of developing wellness programs to help employees live healthier lives. I have 3 points that I'd like to share with you today. First, why are wellness programs good for America? Second, what are the current challenges that employers are facing with their wellness programs today? And third, why is legislation necessary? First, why are wellness programs good for America? Wellness programs help achieve better health outcomes for employees and also have the potential to increase employee productivity by helping to reduce absenteeism due to sickness and disability, improve workforce morale and engagement, and reduce healthcare spending. The prospect of a healthier workforce has compelled a growing number of companies to develop and implement wellness strategies. 65% of respondents to Buck's 2014 wellness survey indicated that they have a wellness strategy. That's up from 49% in 2007. Other surveys estimate that more than 75% of U.S. employees now have access to wellness programs. A critical component of encouraging employers to offer meaningful wellness programs is consistent federal policy that promotes the health of Americans and is aligned across multiple agencies and Congress. As such, employers applaud Congress for working on a bipartisan basis to craft the wellness provision in the Patient Protection and Affordable Care Act that built on the existing wellness program framework created by HIPAA. This is a rare bipartisan provision in the controversial health care reform law and reflects Congress's approval of offering incentives for health contingent wellness programs. Now, as you may recall, HIPAA prohibits group health plan wellness programs from discriminating against individuals in eligibility, benefits, and premiums based on a health factor, which includes, among other things, disability. And for many such programs, the law imposes financial limits, notice obligations, and alternative standards for those unable to meet the program standards. HIPAA also contains privacy and security rules protecting individual health information. Information that is obtained through a wellness program is part of the group health plan, can't be used without an authorization for any reason other than treatment, payment, or healthcare operations. So what's the current challenge? Notwithstanding employers' interest in establishing legally compliant wellness programs and the bipartisan support of Congress and the administration, a great deal of uncertainty exists in current EEOC guidance regarding what constitutes a voluntary wellness program under the Americans with Disabilities Act and how the Genetic Information Non-Discrimination Act applies to common wellness program designs. This legal uncertainty has been exacerbated by enforcement actions initiated by the EEOC regional offices against some employers' HIPAA and PPACA compliant wellness programs. These actions allege that incentives or penalties associated with participation in a group health plan's wellness program violate the ADA and GINA. These actions have had a chilling effect on employer wellness programs. To put it more plainly, currently employers just don't know what to do. On the one hand, they're designing programs that comply with HIPAA and PPACA's clear and comprehensive non-discrimination rules, but on the other hand, still face the risk of litigation for not complying with EEOC's unclear standards. This is very frustrating for employers that care about the well-being of their employees and take seriously their compliance obligations. So, what's the solution? Chairman Klein has introduced the Preserving Employee Wellness Programs Act of 2015, or H.R. 1189, which supports the existing HIPAA and PPACA legislative framework with regard to wellness programs, striking, we believe, the right balance between providing certainty to employers and ensuring an appropriate role for the EEOC to protect employees from discrimination. The Council fully supports advancement of H.R. 1189 and urges members of the subcommittee and full committee to please join Chairman Klein as co-sponsors. Thank you for the opportunity to testify, and the Council and I look forward to working with you to restore certainty to employers focusing on improving the health of their workforce.
Thank you. I recognize Ms. House now for your 5 minutes of testimony.
Thank you. Chairman Wahlberg, Ranking Member Wilson, and all the members of the Workforce Protections Subcommittee. I am Tanya House, Director of Public Policy of the Lawyers Committee for Civil Rights Under Law. I thank you for the opportunity to provide this testimony today in furtherance of the protection of the equal employment and civil rights of all Americans. The Lawyers Committee is a nonpartisan, nonprofit organization established in 1963 at the request of President John F. Kennedy to involve the private bar in providing legal services to address racial discrimination. As Policy Director and as co-chair of the Employment Task Force of the Leadership Conference on Civil and Human Rights, I work with the larger civil rights community on numerous employment issues generally, as well as the necessary enforcement agencies, including the Equal Employment Opportunities Commission, as well as the Department of Justice. In the interest of time, I would like to focus my remarks primarily on the underlying theories that support a more robust EEOC and oppose the passage of legislation that would undermine the civil rights of employees. As this committee is aware, Congress has assigned the EEOC the primary responsibility for enforcing, in the private sector, most of the provisions prohibiting discrimination in employment of every major civil rights law enacted since 1963. Yet H.R. 548, 549, 550, and 1189 all would subtract from the scope of the EEOC's enforcement authority in a way that would primarily serve to eliminate the effective and timely enforcement of civil rights protections for American workers. Furthermore, the claim that such bills would actually enable the EEOC to more efficiently comply with its mandate begs the question of whether supporters of these bills believe the mandate of the EEOC is to eliminate the obligations of employers to not discriminate or allow for the creation of hostile work environments, or instead to protect the rights of employees to not be unfairly discriminated against. Unless the EEOC's mandate has changed within the past 24 hours of me writing this testimony, I would submit that it is the latter. Employee claims of discrimination are not subsiding. Every year during the Obama administration, the EEOC has received between 90 to 100,000 charges of discrimination. Despite a relatively small staff, the Commission has been able to conclude 15 or more of the cases resolved every year with some form of compensation or other benefit to the employee who has charged the employer with discrimination. A recent example is a case that has been prosecuted by the EEOC jointly with the Lawyers Committee, the State of New York, the City of New York, and in this case, the settlement would potentially provide an estimated $12 million in compensation to 400 workers. Critics of the EEOC view the Commission as a government agency that needs to be restrained. The Lawyers Committee and the larger civil rights community fervently reject this belief. In the light of the substantial benefits the Commission obtains for employees, it is not reasonable to evaluate the EEOC based upon a small number of reports highlighted by those opposed generally to the EEOC and the law it enforces. To be clear, H.R. 1189, H.R. 548 would both essentially declare by fiat that certain civil rights laws are null and void in application. Specifically, H.R. 548 would undermine the protections that Title VII provides by codifying the use of unjust stereotypes by employers. On the other hand, H.R. 1189 effectively works to undermine critical civil rights protections and permits workers to be coerced into disclosing sensitive medical and genetic information to their employers, thus enabling employers to shift the cost of health insurance away from them and onto the employee. H.R. 549 would eliminate the ability of the EEOC to more efficiently engage in investigations and lawsuits, instead instituting an unnecessary, duplicative, and untimely and ultimately obstructionist approval process for litigation, while H.R. 550 attempts to legislatively require the EEOC to engage in a process that is currently under review at the Supreme Court in the case of mock mining. Although the claim is made that all of these bills would create a more efficient EEOC, the idea that enabling the blanket disregard of current civil rights laws is incredulous at best. Congress should not disregard the very real existence of ongoing unjust discrimination against American workers. For instance, current estimates are that 70 million Americans have an arrest record for criminal offense. Thus, H.R. 548 would automatically exclude all of these Americans, 70 million Americans, from the workforce. This is not just anecdotal. In the case where the Lawyers Committee is co-counsel, census records for the 2010 process revealed that between 850,000 and 1 million applicants who had FBI arrest records were diverted into a separate screening process where fewer than 1% were hired, while almost 30% of the applicants who remained in the regular pool were hired. The enforcement of our nation's civil rights laws, particularly those in the employment context, is of paramount importance to the Lawyers Committee. If the goal is to enable more effective enforcement on behalf of American workers, we suggest the committee provide for proper funding of the EEOC. I encourage this committee to not move forward with legislation that would undermine the EEOC. The American workers are depending on you to protect the employment rights and simply do the right thing. Thank you.
Thank you. Now, Professor Harriet, we recognize you for your 5 minutes of testimony.
Thank you for this opportunity to testify in support of the proposed Certainty and Enforcement Act. The bill is aimed largely at correcting a narrow problem created by the EEOC's April 25, 2012 guidance, a controversial document aimed at restricting an employer's ability to take into consideration a job applicant's criminal record when hiring. The guidance purports to draw its authority from Title VII, which prohibits employment discrimination based on race, color, religion, sex, or national origin. Of course, it requires some gymnastics to get from that kind of discrimination to discrimination on the basis of criminal record. To do so, the EEOC employs disparate impact theory. Under this controversial theory, which alas was approved by the Supreme Court back in the 1970s in Griggs versus Duke Power Company, intent to discriminate on the basis of race, color, etc. is irrelevant. It is enough the employer's actions have more effect on some protected groups than others, if they are not justified by business necessity. I should add at this juncture that in addition to the narrow problem dealt with the proposed act, there are many other things wrong with this guidance. But given the difficulties of passing major legislation, this bill must be regarded as a good start, one that should enjoy bipartisan support. So let me get to the narrow point of the bill. The bill seeks to resolve a conflict between federal law, or at least the EEOC's conception of federal law, and state law. On the one hand, the guidance is aimed in very vague terms at limiting an employer's discretion to make employment decisions based on the employee's criminal record. Unfortunately, after reading it, even experienced attorneys won't know how to resolve particular cases. But on the other hand, state law sometimes requires employers to decline to hire employees based on their criminal records. So what's the employer to do? The guidance forces employers into an impossible bind. Employers are told that maybe, but only maybe, federal law forbids what state law requires, and that if so, it is their duty to obey federal, not state law. According to the guidance, it depends on the circumstances of each situation, since even the EEOC is not foolish enough to believe that a convicted pedophile should be hired as a camp counselor or that a convicted necrophiliac should be able to get a job at the morgue. Nobody knows where the EEOC will draw the line. All they know is that the agency has been pushing the line very far towards not permitting employers to take criminal convictions into account. The one thing that is clear is that if, in the EEOC's view, federal law forbids what state law demands, the employer's allegiance must be to federal law. Employers are apparently expected to make their best guess as to whether federal law overrules state law in any particular case. In the end, it will be utterly unclear to any conscientious employer exactly what, if anything, the EEOC is attempting to require it to do. Now, it's true that under the Supremacy Clause, federal law trumps state law, but the guidance's lack of clarity makes the situation extremely unfair to employers. It shouldn't be that way. When a law contains catch-22s of this kind, jobs get exported overseas. Expect two kinds of errors. An employer may wrongly conclude that the guidance does not forbid her to follow state law, or she may wrongly conclude that it does. In either case, she's going to be in hot water with some government agency, be it federal or state. The proposed Certainty and Enforcement Act throws the hapless employer a lifeline. It clarifies federal law in one respect. It tells employers that they are free to comply with state law without fear of being found in violation of Title VII on a disparate impact theory. Again, very, very narrow. Since I have a few seconds left on the clock, let me say that an even better proposal would be to overrule the EEOC entirely and restore employer discretion to take into account an employee's criminal record according to her best judgment. Simply exempt decisions based on criminal records from liability for disparate impact. Note that I am not saying that the federal government should do nothing to encourage the hiring of ex-offenders. The government already does this by providing a tax deduction for employers who hire ex-offenders. This carrot approach works much better than the stick because it allows employers to fit the right ex-offender into the right job. Pressuring employees to hire ex-offenders against their better judgment will only result in problems.
Thank you, and thank you each of the panelists for your testimony. I'm sure it will elicit some strong questions. And for that, I recognize the chairman of the full committee, Mr. Klein, sponsor of H.R. 1189, for first round of questioning.
Thank you, Mr. Chairman, for your courtesy in allowing me to ask the first question. We actually won't get you anything, but thanks very much. And thanks
I didn't expect that.
He tries, though. Thanks to the witnesses for being here. We appreciate very much your expert testimony. Because 1189 is my bill, the Preserving Employee Wellness Programs Act, I want to dig into that a little bit. And Ms. Simon, I'm going to go to you. We've had very expert testimony from all of you, but as you say in your testimony, quote, "It is impossible for employers to abide by rules that do not exist," close quote. EEOC's lack of a clear position is what prompted my bill, so the businesses would have a clear path forward. So we're trying to get a legislative fix, but last week the EEOC apparently recognized this problem, at least to some degree, and sent a proposed rule to OMB that will purportedly address concerns that we've been talking about today. In your opinion, what should this regulation include to address the issues that we were talking about of clarity and flexibility for employers and their employee wellness programs?
Thank you, Chairman Klein, for your question. Great question. And, I look forward to seeing that EEOC guidance very much. We've certainly been waiting a long time for it. And hopefully, it's going to prove to be as responsive and as flexible as your bill, without placing any new requirements on employers. In our opinion, the EEOC should deem employer-sponsored group health plan wellness programs that offer incentives and are currently compliant with HIPAA and PPACA as meeting the wellness exception of the ADA and GINA. Employers are investing significant resources and compliance efforts into their wellness programs to ensure that all employees can take advantage of them and so that all of them are treated fairly. And what they really need is comprehensive, workable, and consistent standards to follow, and they need those right now.
Thank you. I also am eagerly awaiting to see what comes out of OMB. I'd like to say I'm optimistic, but we still very well may need H.R. 1189, but we'll see. So there have been some questions raised about privacy, of course, and that people don't want employers to have all of their personal information. So let's talk about HIPAA. Ms. Simon, I'm going to stay with you if that's all right. Under HIPAA, can an employer see the private health information of an employee or their family who participates in the wellness program?
Again, thank you. That's a very important question and one that certainly employers take very seriously. If a wellness program, is part of the group health plan, then it would be covered by the HIPAA privacy and security rules, which I mentioned earlier in my testimony. Now, that rule says that the information could not be used without an express authorization for anything other than treatment, payment, or healthcare operations as set forth in that law. Thus, nobody outside of that HIPAA firewall would be able to discuss that information for purposes other than those that are intended within the group health plan. The rules are very, very specific and put the onus on the covered entity, and in this case it's the group health plan, to protect the information as mandated by HIPAA. And the law requires extensive policies and procedures to be drafted and met, notice to be given to plan participants, risk assessments to be completed, and training to be provided to any individuals handling the protected health information. Your bill is aimed at wellness programs provided under a group health plan, so the HIPAA rules do in fact provide that protection. In most cases with large employers, there's usually a wellness vendor that's the go-between the employee and the employer, and so it would be considered a HIPAA business associate. While that vendor is technically an agent of the employer, most contracts specify that the employer will really only receive information that's de-identified from that vendor. And so business associates, because they're held as liable and to that same threshold as covered entities under HIPAA, we're hoping that then any third party that does have a business associate agreement with the group health plan would be held to that same level, that same standard, and the information would then, of course, be protected.
Thank you. I see my time has expired. I yield back.
Thank the gentleman. I now recognize the gentleman from Virginia and the ranking member of the full committee, Mr. Scott.
Thank you, Mr. Chairman. Mr. Keogh, does your testimony include the statement that the EEOC does not have the authority to issue regulations under Title VII?
Yes, it does. The EEOC does not have authority to issue substantive regulations under Title VII. Procedural regulations are okay.
Well, I just want to enter into the record with unanimous consent the Title VII U.S. 42 U.S.C. 2000E12 subsection A. The Commission shall have the authority from time to time to issue, amend, rescind suitable procedural regulations to carry out the provisions of this chapter. Regulations issued under this section shall be in conformity with the standards and limitations of subsection 2. I'd like unanimous consent to have this in the record.
Hearing no objection, it will be entered.
Thank you. Ms. House, can you remind us why the Griggs decision was so important?
With regard to Title VII application,
Right. If you didn't have the disparate impact, if you had a discrete person with ill intent, what would happen if you didn't have Griggs?
well, if we weren't able to have, without Griggs, we would not be able to sufficiently provide the necessary evidence and showcase the discrimination that has been occurring across this country unintentionally, but effectively, particularly against communities of color, against those who have traditionally discriminated against those women as well as people with disabilities. That is a critical component within civil rights law that I think is effectively utilized within civil rights, across the civil rights community.
Now, if you had a disparate impact, but it was job-related, would Griggs prohibit the consideration of a job-related criteria, although it had a disparate impact?
No, it would not.
It would not. Does federal law guidance, does EEOC guidance require employers to hire those with criminal records in violation of state law?
No, it does not.
How does ban the box fit into this discussion?
Well, ban the box is an attempt to eliminate the blanket elimination of those that have a criminal history. It creates, there are those employers that will summarily dismiss those with a criminal history, even potentially an arrest record, from even applying for any type of job within that sector with that employer. And ban the box eliminates that exclusion, that blanket exclusion, and it is something that I know the Lawyers Committee, the entire civil rights community has been very supportive of, and we have been working with other companies and other organizations to eliminate that blanket exclusion.
Does the banning the box prohibit consideration of criminal records?
No, it does not. In fact, what it does, it eliminates the blanket exclusion. It does not prohibit an employer from having an individualized assessment of those that might have a criminal record. In fact, it just allows for there to be an equitable consideration of an employee as they're attempting to apply for a job and allow them the opportunity to provide the necessary review that they deserve should this, if their criminal history does become an issue within their employment.
Now, is the guidance consistent with or in violation of the Griggs principle?
No, it is not. In fact, it specifically creates and allows for there to be an employer to provide a business necessity should they have a particular exclusion of those that have certain criminal histories. I think that there has been a use of, the continued use of hyperbole when we talk about those that have a background of sexual assault and they being allowed to work in daycare or childcare environments. That would not be allowable nor acceptable under the current guidance that has been issued by the EEOC. And in fact, it is not something that would be permissible that any of the civil rights community would allow.
Thank you, Mr. Chairman.
I thank the gentleman. Continuing that bit of questioning, I recognize myself for my 5 minutes of questioning. Professor Harriet, appreciated your testimony and the real-life examples that I would never thought of hiring a necrophiliac for a job in a morgue. I guess we do have to consider what our laws do and what guidelines are in place. In your testimony, you said EEOC's 2012 enforcement guidance on criminal background checks is vague and uncertain as to an employer's duty. The employer will have no way of knowing whether EEOC will agree with its judgment in using background checks. You also note that recent background check cases in which EEOC lost and was harshly criticized by the courts. Is the EEOC's enforcement guidance going to be of any help to the general counsel or regional attorneys pursuing cases brought against employers for using background checks?
Yeah, I get your drift. If it's so easy for employers to understand when an employer can be legally liable for failing to hire an applicant on account of his criminal record, then why does the EEOC itself get it wrong so often? There have actually been a number of cases where the EEOC has brought actions and they have been slapped down by the courts.
Any specifics you can give to that, for example?
The two cases that come to mind for me, because they've both been in the U.S. Court of Appeals, are Freeman case and People Mark. In both those cases, the EEOC brought an action against an employer based on their criminal background checks policy. And in both cases, both the district court and the Court of Appeals slapped the EEOC down pretty hard. And if the EEOC itself is having a difficult time figuring out what constitutes a good case, then how are employers supposed to get that right? In addition, the EEOC has been conducting investigations against companies that you'd think would have a pretty strong case, like G4S, which testified in front of the U.S. Commission on Civil Rights. One of their officers did. And they're a company that hires security guards. I mean, that's their business. They supply security guards to other companies. That's a job where you would think that the argument that they should be able to consider criminal background was very strong. But the EEOC did not agree and had conducted a very, very long investigation of that company.
Okay, thank you. Mr. Kehoe, in a number of cases in recent years, the EEOC has been sanctioned and ordered to pay the defendant's attorneys fees and costs for pursuing claims that are frivolous, groundless, and without merit. In other cases, the agency has lost on summary judgment, has been severely criticized by the courts. From your position, having consulted with a EEOC commission member, should Congress be concerned about these outcomes, or do you consider them to be the normal course of business in an agency authorized to enforce federal laws and litigation?
Chairman Walberg, thank you for that question. Of course, Congress should be concerned. Congress has given a budget of $360 million to the EEOC to go eradicate discrimination. And on many of its large cases, the EEOC is, to put it in monopoly words, failing to get past go because they can't even establish a prima facie case of discrimination. The EEOC has immense subpoena power to get this information before filing any sort of litigation. And while no one would expect the EEOC to bat 1,000 on all of its cases, the troubling trend, and if it were only one or two cases, then maybe Congress should be less concerned. But there are dozens of cases where the EEOC has been sanctioned and had their cases thrown out of court.
Would the commissioner's involvement in overseeing some of these cases and looking into them beforehand, before moving forward, be helpful for the general counsel?
Having commissioner review adds another layer of oversight, a layer of oversight to the regional attorneys who want to bring the case, a layer of oversight to the general counsel who signs all the filings. It absolutely has the potential to ensure that better cases are being brought. The review period for commissioners allows commissioners to ask questions. The issue is on many cases that are filed by the EEOC, the commissioners find out by press release or social media. They're not even involved. And I think the issue of when making policy through litigation, it comes up. At the end of the day, the general counsel is not the agency's policymaker. He is just the litigator. Any general counsel.
Thank you. My time has expired. I now recognize the ranking member of this subcommittee, Ms. Wilson, the gentlelady from Florida.
Thank you, Mr. Chair, and thank you to the committee. I enjoyed listening to your testimony. I have a question first for Ms. Clayhouse. This year is the 50th anniversary of the EEOC opening its doors. Now, these are 3 questions. Do you believe that the EEOC's mission is as relevant today as it was 50 years ago? What do you believe are the most pressing and emerging forms of discrimination that merits the EEOC's attention? And could you please share your views on some of the challenges that face the EEOC?
Thank you for that 3-part question. You're right. It is 50 years since the opening the doors of the EEOC, and though we may not face some of the blatant discriminatory policies that existed when the EEOC was originally founded, we still face enormous discrimination within the employment sector. And if that was not the case, we would not have upwards of 90 to 100,000 claims that are continually submitted to the EEOC, complaints of discrimination. I think that some of the most pressing issues that we are facing today are with regard to what we've spoken about already, the criminal and credit history checks. I think that's particularly important because we are right now dealing with an economy that has had been failing, that is on the upward swing. However, as a result of that failure, we have millions of people who have had their credit history affected. We have those that have criminal background checks. We have 1 in 4 African American men that have been in prison or are in prison at this point in time, and therefore have criminal background history. And if we are summarily prohibiting all of those individuals that have bad credit or a prior conviction from the employment sector, we are eliminating millions of people from the work and from the economy. And that is not good for anyone. And I would hope that that is not something that any of the members of Congress here would advocate here today. With regard to the challenges, I think that we need to look at a number of issues, particularly the hiring practice, as I said, of employers right now. We need to consider the pay disparities that continue to exist between men and women, as well as people with disabilities. And I think that we need to consider and look at the implicit bias that continues to exist, particularly when you're talking about the same and similarly situated resumes that are submitted to employers, yet with a different name, one that might be more ethnically diverse. And you have instances where that resume with a more ethnically diverse name would be eliminated or excluded. And that type of implicit bias is has been prevalent, as we're seeing, not only in the employment sector, but other sectors as well.
Thank you. This question is for Ms. Harriet. Ms. Harriet, I have a long background in helping African American boys and men achieve their status in life. And there's a real problem with the school to prison pipeline. Mm-hmm. So my concern has to do that in 100 cities and counties in 14 states, they have adopted the ban the box policies because they realize that our criminal justice system is biased and that the people of color are disproportionately institutionalized and arrested and harassed. So I want to ask you, if cities and counties are trying to ban the box, why do you think the EEOC is overreaching?
Well, I think that employers, like cities and counties, should have that option to ban the box, and that's perfectly acceptable. And many employers would ban the box as well, many private employers. I think the federal tax deduction that allows employers to make the choice to hire someone who they know is an ex-offender is an excellent program. But the notion that private employers should be coerced in this way, I think, is a big mistake. There are many jobs for which it makes perfect sense for an employer to decide this is not a situation where I want to take a chance on an ex-offender. And nobody is in a better position to make that decision than the employer itself. If the EEOC is in a position to second-guess them, then what's going to happen is that employers will bend over backwards to avoid the possibility that they will be brought into an EEOC lawsuit. And when that happens, tragedies are going to ensue. It's not always appropriate to hire an ex-offender in a job. Jobs that involve visits to private citizens' homes, jobs involving, say, nursing homes, schools, that's not a good place to put an ex-offender in every case. There are exceptions, but the best person to make the judgment about when that exception has come up is not the EEOC, but rather the employer, because the employer knows the job, and the employer often knows something about the ex-offender that the EEOC does not know. It's not always possible to govern these things inside the beltway, as it were.
Thank you. The gentlelady's time has expired. I'll now recognize the gentleman from Virginia, Mr. Brett.
Yeah, thank you to all that are with us today for your testimony. I taught economic justice for the last 18 years at Randolph-Macon College, and so I think it's the intent of everyone here, and sometimes the partisan hyperbole goes a little overboard, but I think everyone here is in favor of justice for everybody and equal treatment under the law for everybody. And so I applaud all of you for your statements. I think it just comes down to kind of common sense and where the pendulum is. And so I think you've all done an outstanding job today of showing us that it looks like the previous comments just offered up, the EEOC is overreaching in some cases where the employer is the better judge of what should be taking place. And at the same time, our justice system allows for individuals under law to contest that. And so I don't have much more to add beyond what our panelists today have offered up. Thank you very much for being with us. I yield back, Mr. Chairman. Yield my time back to the chairman, yes.
Thank you. Thank you for yielding your time. It's always good to get a time from a professor. And I appreciate that, because I have a couple more questions I would like to try to get in here. Mr. Kehoe, the Supreme Court has granted review in Mack Mining versus EEOC to decide whether the agency's statutory duty to conciliate must be performed in good faith and is subject to judicial review. Why is it important, from your perspective and your placement with the EEOC before this, for courts to be able to review EEOC's conciliation efforts?
Thank you for that question. I think the most important reason for courts to be able to review whether the EEOC complies with its statutory mandate is because it is a statutory mandate. The Title VII requires the EEOC to conciliate because the goal of the employment discrimination laws is to reach a settlement prior to actually filing litigation. For 40 years, courts have reviewed whether or not the EEOC has complied with its conciliation requirements. Congress, in the 1972 amendments to Title VII, considered whether to exempt the EEOC's conciliation requirements from judicial review. They reviewed a bill. They didn't enact that bill. So it's pretty clear that congressional intent requires the EEOC to conciliate in good faith, because here's the situation.
Have they consistently abused that process of conciliation?
Well, there have been several cases that have been thrown out of court for failure to conciliate. The biggest one is EEOC versus CRST. The court had awarded $4.7 million in damages, and though that award has been remanded by the Eighth Circuit back to the trial court, at the end of the day in CRST, the EEOC spent 10 years investigating and litigating, brought a huge class case for 154 women who were allegedly sexually harassed, and they settled the case after just about 10 years for $50,000 after 153 women who claimed they were sexually harassed were left out in the cold because the EEOC didn't follow the rules.
Let me move on to another case. In the U.S. Steel case, EEOC alleged that random drug and alcohol testing as agreed to in the collective bargaining agreement entered into by U.S. Steel and the Steelworkers Union violated the Americans with Disabilities Act. The policy applied to very dangerous jobs where following safety rules were critically important. I worked for U.S. Steel in some of those same dangerous jobs myself as a U.S. Steel Steelworkers Union member. Predictably, the court held the policy was job-related and consistent with business necessity, dismissing the case on summary judgment. Clearly, this was not a good case either. Why would EEOC bring such a case, and what does it say about the EEOC and how it decides to file lawsuits?
Well, I think specifically with U.S. Steel, the first point of order would be that was one of those cases where a good amount of commissioners found out about the case via a press release. That case was brought, essentially, the policy that U.S. Steel had implemented essentially said for probationary employees, you can't show up to work drunk at the steel mill. And the EEOC decided that that was a violation of the ADA to do random alcohol testing. Now, it would stand to reason that any sort of safety policy that requires people in steel mills to show up to work sober would clearly be job-related.
My time has expired, and I think that punctuates it. I now recognize the gentleman from Wisconsin, Mr. Pokin.
Thank you, Mr. Chairman, and thank you to the witnesses. I'm going to comment. I got the feeling I'm going to be doing this every subcommittee. We did a good job of lawyering up again. We've got a lot of lawyers on the panel. It would be nice maybe to have some of the small business owners who are affected. We're going to have to change the name of the committee pretty soon to Education Workforce via the judicial system at the rate we're going. But we do have a lot of lawyers.
I would just, for the record, say the business owners are afraid of being sued, so they send their attorneys.
Yeah, but that's sometimes why we get the creative answers that we get. And sometimes I'd much rather have things coming from being a small business owner for 28 years and not being a lawyer. I guess maybe that's the realm I deal with, but since it's going to affect the businesses, I like to have it from that. Let me ask Ms. Harriet just a quick question. Do you view the EEOC's arrest and conviction guidance as a radical departure in enforcement?
Back a few years ago, quite a few years ago, during the, mostly during the Carter administration, this was kind of a hot issue, what to do about criminal background checks and such. And there were a few cases a little bit before that as well. And it was very hot at the time. And then the EEOC started backing away from the policies at that point. For example, the policy that someone mentioned today about that involved Clarence Thomas was actually moving back, cutting back on the policy, not putting it forward. So there is a history, but the April 2012 guidance goes much further in several ways. It basically returns that issue to that issue with kind of a vengeance, I would say. First of all, it states that even if there is a state or local law that requires a background check and requires that employers refuse to
Sure.
hire.
If I can reclaim my time, and this is the problem, I have no offense, I know you're a law professor, but you know, the answer was usually falls in the yes or no sort of.
But it can't. I mean, answers don't really do that. That's why I came here. But at any rate, it does.
I reclaim my time. I'm sorry, ma'am. Please let me finish. So what I was trying to ask you, which you did your best to dance around, was that this is the policy in place since I believe it's 1987 when then Commissioner, and you mentioned Clarence Thomas was there. So
No.
Well, it is. It's exactly what it is. So let me do this. Let me ask the question. In Madison, Wisconsin, we recently had a shooting of a young African-American male, 19. Brought up a lot of issues around. We have 8 times the arrest record of African-American males in Madison area, twice the state incarceration of African-American males. Clearly, this affects employment. I recently went to the job center in Dane County, and we met with people who are chronically employed. 70 to 75% of the people that we met with had a felony on their record. That's the real problem. You can have all the legal talk, and by the way, you do get the point for the most creative answer of saying jobs will be exported overseas because of this. It's going in my little board back in the office because that was beyond amazing on creativity. But the bottom line is this affects real people. And so let me go to Ms. House specifically. I know they like to talk anecdotally through legal cases when we know 93% of the cases EEOC brings to court in federal court is successful, and 82% of those that are systemic cases are successful. So this little anecdote, governing by anecdote, is always very dangerous. You brought up a study, a very specific study that said 850,000 to 1 million people in this study who had an arrest record. Of that 70 million people, 1% got hired versus 30% in the other pool. Can you just talk a little bit more about that? Because that's specific and relatable rather than anecdotal. And if you can do it in a succinct, non-lawyerish answer, I'd really appreciate it.
Absolutely. Sure, absolutely. That is actually an ongoing case that the Lawyers Committee is in litigation with, and that is a case against the U.S. Census Bureau. And the reason that I mention this is because, as you said, it's not anecdotal. This is a reality. We're talking about almost 1 million people that were summarily excluded from even being census workers, even though most of them had previously been census workers. And so, as you properly indicated, we're talking about, most of those being excluded and being sent to a secondary review, and so therefore not included in the initial application for the Census Bureau. And I think that that's extremely important to recognize, and we're in ongoing litigation, so I can't get into more specifics regarding the negotiations and what that will entail, but I do think it is particularly relevant.
Yeah, and if I can see the yellow light up, Mr. Chairman, I'll be cognizant of that. But specifically, I think in the testimony that Ms. Harriet brought up, she talked about the problem in Virginia, I think, in nursing homes. Yet EEOC didn't file any cases against nursing homes for using criminal background checks as a basis of employment in Virginia. So again, I think what we're finding is often certain people are using anecdotes and hyperbole when the reality that I'm seeing, at least back home in Wisconsin, is that when we've got 70 to 75% of the people who are chronically employed, specifically with a felony, and I've done this for 28 years. I'm a small business owner. I know it is using...
Employers can't wait until they are sued by the EEOC.
The gentleman's time has expired. We'll move on with the next questioning. And I recognize now the gentlelady from North Carolina, Ms. Adams.
Thank you, Mr. Chair, and thank you all for your testimony. Ms. House, during your testimony on the Certainty and Enforcement Act, you mentioned that 70 million Americans would automatically be excluded from the employment sector because of criminal background searches, with the greatest impact being felt in the African American community. According to the Crime and Delinquency Journal, by age 23, 49% of black males and 44% of Hispanic males have been arrested. Can you speak to the effect that this legislation would have on already high employment rate for African Americans and Hispanics, and how it in turn would affect their respective communities?
Sure. And, as I indicated previously, it would exclude a great proportion and disproportionately impact, as you indicated, African Americans, communities of color, particularly Hispanics and other traditionally disenfranchised. And I think that what you're talking about is you're disenfranchising people throughout their career. So essentially, because of a arrest, it could be an arrest, because I will say for the record that many of the databases that employers are reviewing are including arrests. So you may not have ultimately been convicted. And so therefore, you do have, as a result of these past arrests or convictions that could have happened upwards of 10 to 15 years ago, that people are no longer able to obtain good employment that ultimately affects their entire family, not only just them, but throughout their livelihood.
Okay, so what then would be the impact on the already high employment rate for African Americans and Hispanic?
It increases. I mean, the unemployment rate continues to increase. It does not go down despite any potential job creation programs that this administration or other would employ, because employers are automatically excluding those that have an arrest or a conviction record.
Okay, can you touch for a moment on the criminalization of people of color in the U.S. and how this bill would exacerbate that?
Well, I think that this bill it codifies the stereotype that those that have a prior arrest record or conviction are therefore unemployable and no longer and not fit to engage in the American dream and provide for their families. It is a stereotype, it's a bias. And I think that I've heard that, we continue to hear that throughout many of those who oppose the guidance, but I will say that there are a variety of research material that indicates that, in fact, those that have prior convictions or arrest records over 10 years are no more likely to commit another crime than someone of that same age without a previous arrest or conviction record.
Okay, people of color more often than not have poor credit because of past forms of discrimination and limit educational employment, borrowing, and housing opportunities. This is especially alarming in the African American community, where only 25% of households have a credit score of about 700. So how can the use of someone's credit score, credit history, perpetuate extended unemployment and poverty?
Sure. Currently, because we are still awaiting further guidance on how employers will properly or how they should properly utilize credit history checks, what's happening right now is that, similar to criminal background checks, employers are using credit checks without properly understanding exactly what is the rationale for people's bad history. They're using that as a similar type of exclusionary policy to be employed with certain positions. So, for example, someone's credit could be detrimentally affected by a medical procedure or as a result of prior inability to pay for hospital bills after they were sick or their family member was sick. However, because it does detrimentally affect their credit, they are therefore excluded from potentially additional employment, say, within a bank, because they have bad credit. And there's no individualized assessment given to them with regard to whether or not this is in fact a related or a proper use of a credit history check.
Thank you, Mr. Chair. I yield back.
I thank the gentlelady. And I recognize the gentleman from California, Mr. Desagnier.
Thank you, Mr. Chairman. And like my friend from Wisconsin, I struggle with being a former small business owner who was going to go to law school and chose not to and continued to follow that choice. And I appreciate the chairman's comments as well as being a small employer who worried about lawyering up. So my questions are about an issue that I spent a good deal of time on in the California legislature and with a constituent who was a longtime chairman of Safeway and tried to do employee wellness programs, but he did that through the meet and confer process for all of his non-management folks. So while I believe that there's evidence that obviously wellness programs are good for everybody, they help to control costs, but I also believe as a former employer that sometimes, to sort of borrow what Professor Harriet said, that although you can't mandate from the Beltway, sometimes or oftentimes managing people, you try to do it collaboratively and rather than force them to do things. So the question is to Ms. House to begin with. The Genetic Information Non-Discrimination Act made sure that wellness programs and that information were given up voluntarily. The Preserving Employee Wellness Programs Act that Congress currently is considering overrides the GINA provision that requires that participation in wellness programs are voluntary. So much of this is being defined in the court system right now. Is that not true?
I'm sorry, I couldn't hear that last
In
part.
terms of the decision of whether it's voluntary to ask for this information or not, there are court cases, are there not, right now, that may or may not help us determine that?
Yeah, there's ongoing litigation. I don't have at my disposal all of that case law to present to you. I can provide that for you after this hearing is finished. But yes, I mean, there continues to be ongoing litigation, and I think that we need to, that is something that continually needs to be assessed, but the primary focus should be voluntary.
Right.
That this is not something that should be forced upon an employee, and then ultimately create a situation where they're providing unnecessary information that would detrimentally affect their ability to obtain proper insurance.
It's my understanding that the research so far, although it's not conclusive, is that these decisions are best made between an individual and their doctor. Is that not true?
I would submit that, yes, but I will say that I'm not as well versed on some of the documentation with regard to the wellness program, so I don't want to give you misinformation. But yes, I mean sounds reasonable. Yes.
Anyone else care to comment on the panel? Anyone with more expertise or a different opinion?
If you don't mind, I wouldn't mind commenting a little bit on your question about voluntariness.
Yes.
You know,
briefly, please.
I think that we understand the term voluntary as used certainly in the medical examination and disability inquiry provisions. I think that the first question to ask is, does the provision under the ADA, and also when we're talking about GINA, allow voluntary to first have a dollar figure attached to it, which seems to be one of the first issues that we hear about in the employer community. And the answer to that question was actually answered in GINA guidance, where the EEOC shows how an HRA can legally ask about health conditions and offer a $150 incentive so long as the questions related to family medical history aren't required to be answered to receive the financial inducement. The quote is, "We have concluded that covered entities may offer certain kinds of financial inducements to encourage participation in health services under certain circumstances." So first, with respect to voluntariness, we know that a financial incentive would probably be okay. So then the next question is, how much?
Excuse me, that's under existing law.
Yeah, yep. And I can give you citations for the record if you'd like. So then the next question is, how much of a financial incentive would be okay for the incentive to be considered voluntary? Because clearly the $150 figure was just illustrative. And to that, we can again turn to other agencies and your congressional intent and point to the 30 and 50% rule under HIPAA. Even though the HIPAA rule doesn't actually use the word...
I'm going to jump in here and stop you before the red light goes on. So my comment would be that all of that is consistent with the current law. So
that is absolutely correct.
I would just conclude is what's the necessity of the new proposal to change that. Thank you, Mr. Chairman.
I thank the gentleman, and I thank the witnesses for your attention to our questions and responses. And before we go to closing comments, for the record, I'd like to submit a number of letters that were supplied to us on this issue expressing their concerns, their ideas from business groups, child care groups, etc. That would be good to have in our record. Hearing no objection, they'll be submitted. I now recognize the gentlelady from Florida, the ranking member, Ms. Wilson.
Thank you, Mr. Chair. In closing, I would like to thank once again all of our witnesses for coming, and I would like to highlight the majority's attempt to roll back a body of laws that have helped protect American workers from race, sex, age, and disability-based discrimination for over 50 years. 50 years, that's a long time. The laws we have discussed today will dramatically limit the effectiveness of the EEOC and leave millions of workers vulnerable to an employer's abuse of power and discrimination. As I mentioned in my opening statements, the name of our subcommittee is Workforce Protections. These bills will essentially undermine the clear and apparent purpose of our subcommittee, which is to provide a safe and amicable working environment for American workers and ensure that employers engage in fair and equitable hiring practices. All of the detailed postings reporting requirements in H.R. 550 seem to be designed to keep lawyers with a job, to keep filing lawsuits. Where? Tell me, where does the average worker who really doesn't want to go to court but wants to do his or her job without experiencing discrimination go to get justice? You are creating roadblocks by making the EEOC too busy posting things up online, taking notes on cases, getting certified to do conciliation. None of these bills specifically empower the average worker to be protected from discrimination. There are so many roadblocks. And as the EEOC won 93% of cases in federal court and 82% of systemic cases, 84% of the businesses owners in 2014 responding, they are complying with the EEOC's arrest and conviction guidance. And there is a big difference between arrest and conviction. And that's why we need a ban the box policy. As members of this subcommittee, we should be doing everything in our power to support American workers and not be in the business of setting up roadblocks to essential protections from workplace discrimination. Again, Mr. Speaker, I respectfully ask that we call another hearing, and this time we want to hear from the EEOC commissioners before moving forward, so that we can ensure that these bills will not set up unnecessary roadblocks for fair and timely resolution of discrimination claims. Remember, we are the Subcommittee on Workforce Protections. That's the workers. Thank you, and I yield back the rest of my time.
I thank the gentlelady, and I concur. We are the Subcommittee on Workforce Protections, and this is our job to do, and we will do it with all due diligence as necessary, including the hearings we have or may have in the future. We are responsible to make sure that the workforce is protected, but we want to make sure as well as when we do that, that the places that the workforce work are protected as well, that we have that symbiotic relationship that says there will be success in the workplace because there are successful, safe workers that are doing jobs that they are fit and prepared to do. And they are protected against even, should I say, unthinking action and requirements that don't recognize the reality of the workplace or the workforce. To think that there would be a steel worker that would go to work drunk in an unsafe situation like the number 2 electric furnace that I worked at and be hurt because U.S. Steel would be prohibited from doing its due diligence and making sure the person meets the needs and the concerns. The fact that we would be putting employees in places of work without questioning that they physically could not handle because of age, because of disability, even if it's in a restaurant that's high intensity and serves customers from 7 o'clock on, and it takes someone with more stamina than me to work in that restaurant. And yet, because of laws that don't deal with flexibility and look at the issue not to discriminate against a person or a class of persons, but understands the workplace and wants people to succeed, yes, for the benefit of the employer, but also the benefit of the employee as well. To think that there's a commission that has been appointed to deal with these issues and make sure that indeed employees are cared for and that their suits that are brought against employers for discrimination on basis of the law, that there's a 70,000 person backlog or case backlog. And yet we can talk about the success rate of systemic cases, for instance, yet they're relatively few. And sadly, a good number of those are being thrown out. And equally as sad, taxpayers are footing the bill to pay for the costs of these frivolous suits. We have contradictory laws that our employers and employees are expected to carry out and live under, both federal and state and federal, and even federal and federal, with Obamacare versus the Civil Rights Act and the Disabilities Act. Those are concerns, and that's why we have this hearing, and that's why these 4 bills have been initiated, and that's why we're doing due diligence in making sure that these bills attack the problem that's there, and not something that we're just guessing at. We want workers to be successful. We want people to be not discriminated against. We want employers to be successful and not hindered by laws that go far afield from what they want to do and carrying on with their employees as well. So I appreciate the panel today. I appreciate my subcommittee members and the diligence that you put to this hearing, and we look forward to further movement down the road. Without further agenda before this subcommittee, I declare it adjourned.